Welcome to another AMC Workshop Wednesday. These events are for your education and information about HOA, HOA things that you need to know, HOA items and HOA information. My name is Dwayne Williams, and I am Vice President of Marketing for AMC. Today's topic is bad docs equals bad news. And I know this may not sound like the most exciting topic for many of you, but believe me, your governing documents are super duper important. It can have a huge impact on your association. So before we begin, I want to go over a couple basic housekeeping items for you. All your cameras and mics are muted. And if you have a question, please put it in chat and we'll be reviewing the chat. And after that, we'll have a Q&A. So I'm gonna briefly go over our agenda. First, we're gonna have our guest speaker, followed by our Q&A, followed by the world famous AMC raffle, followed by, then we'll close the event and talk about our next webinar, okay? So with that being said, what I'd like to do is introduce our guest speaker. Our guest speaker has over 20 years experience in HOA law and HOA governing documents. Our guest speaker is Bruce Inman. He's owner of Bruce Inman LLP Law Offices, and he's joining us from his vacation site. So Bruce, thank you for joining us. Bruce.
No problem. Happy to be here. So I'm just curious, did you want to discuss sponsors ahead of time or brought to you by, or would you like me to go into my discussion of governing documents?
We'll cover the sponsors when we get past the Q&A. Thank you.
Excellent. You bet. Excellent. Well, good afternoon. Bad documents is bad news is the topic. And I thought I'd begin with a discussion of how I view homeowner association governance, because it taints the entire perspective of how I approach governing document revisions. And I view associations essentially as private governments. And my comment is, your private governments that are really kind of more of a government than the typical government. And here's my thinking that colors how I view and advise my clients. Don't go ahead tomorrow and paint your house purple, LA Laker purple, no less. Do you think the city of Sacramento, city of Roseville, city of Rockland, Sac County, Placer County, they're going to care? No, they're not going to care. But you know who's going to care is your association. So you've got your home, and yet your property, which government is telling you what you can and can't do with your property? Don't pay your property taxes 5 years before Sac County assessor, Placer County assessor, El Dorado County assessor comes after you saying, we want our money and we're going to take your property. Don't pay your HOA assessments 1 year or $1,800. And you could end up losing your home without a judge ever even knowing about it. So I go, okay, who's the tax collector here? Is it the government as we know it or the private government? And with that in mind, I view the governing document process as doggone it. If the government's that powerful, the government can tell you what to do, we better be sure what are the ground rules for this government. And you know, the Constitution of the United States is, you know, we the people. And if you've got developer documents, it is the declarant telling you, you know, this is the vision that they have for the documents. A frustrating part of that is any developer documents have Department of Real Estate regulations in them. And some of those DRE regulations are more than 25 years old and are not really even applicable. And some key examples of that, the DRE requires a quorum percentage for members to even be allowed to pick directors. A minimum number of people have to vote. That's not how it works. Last November, we had an election. We didn't have a minimum threshold before a city council member could be elected. It was whoever voted decided. And what had happened is the regulations were written in an era where all your elections were held at meetings where everyone would show up, raise their hand and vote, or write it on a ballot at a meeting. And so the idea was, shoot, you don't want to have the board of directors call, or the members call for an election at Thanksgiving because half the people are out of town, and you could get a complete change in your governance. Well, the legislature took care of that by making the ballot process a 30-day ballot process. With a 30-day ballot process, you don't need to have a minimum threshold of folks showing up before you can have a meeting. So you've got this regulation that talks about minimum quorum percentages that doesn't even really make sense anymore. You've also got cumulative voting. And the idea behind that was the developer is going to control most of the seats on the board of directors. So we better have a way to make sure the homeowners at least get folks on the board. Well, that concept is not applicable to your community if the developer's been gone for years, and yet you're stuck with that same concept. So that's another example of a provision that the DRE regs has in place that's not even needed. The regulations are so behind the times, they actually have a provision that talks about the board of directors being able to act without a meeting. Well, the Open Meetings Act was written to specifically require your board of directors to meet, notice the members they're going to have it, and make decisions at an actual meeting. So here we've got developer-based documents have provisions in them that are not even legal under the current law. And which goes back to the, well, wait a minute. I've got my governing documents. I've got this powerful government that can tell me what I can do with my property and make me pay money. And yet they hand me documents, and the documents don't even necessarily apply. Some of the provisions don't even make sense. And I think so. One of the temptations is to go, well, fine. We'll just follow the civil code, because the civil code, it's called the Davis-Stirling Common Interest Development Act. It's Civil Code Section 4000 to 6500. We'll just follow that. Well, the legislature can't make up their mind. They write every year they change the Davis-Stirling Act. A provision gets added or altered every single year. And the Department of Real Estate, or the legislature, keeps moving the target. And so they've got provisions in there that say, notwithstanding what your documents say, here's what you got to do. So you can't even follow your documents. You have to go, okay, well, what's the legislature tell me I have to do? And whether or not I follow my documents, do I follow the statute? Well, 16 times the Davis-Stirling Act says, I don't care what your documents say, notwithstanding whatever's in your documents, here's what you've got to do. And so you can't just simply read your documents and follow them. So never mind, even if they're new, the Department of Real Estate language doesn't matter. You have to follow the civil code. So actually, I got to check one thing here since, excuse me a second while I keep my notes here going. There we go. So some of the provisions that the legislature keeps tinkering with deal with whether or not you can have artificial turf, whether or not you can have certain plants in your yard, pressure washing your home. If you've got language that mandates you have to do that, you can't be required to. Rental restrictions, electric vehicle charging stations, clotheslines in your backyard. Doesn't matter what your documents say, the legislature has decided here's what the law is going to be. And so you've got 16 different times they say, don't read your documents. You just follow the law. So with that in mind, you kind of go, well, do I even need to follow my documents? And this is where it gets really frustrating. 24 times in the Davis-Stirling Act, the legislature has said, this is the law. Unless your documents say otherwise. So what is it? Do I follow the Davis-Stirling Act? Do I follow my developer documents that don't apply? Do I governing documents, statute, you have to constantly double check. You have to have both of them in front of you. And that's where you end up with, bad docs is bad news. Shoot, it's documents of any length of time are inherently going to be a challenge. So with that in mind, consider that for maintenance, here's one the legislature slipped in that is catching a lot of associations off guard. In 2017, they changed the law regarding who maintains what. It used to be that for a condominium or a attached plan development, if you had a balcony, for example, exclusive use common area, that you were responsible for, the statute had you maintaining your balcony, you repaired your balcony, and you replaced any aspect of it. And in 2017, they changed the law that says, no. Owners, you maintain your balcony, but the repair and replacement is the association's, unless your documents say otherwise. It's back to that dang unless stuff. So all of a sudden, if your documents were not written anticipating this issue, your association may have an obligation for repair and replacement for balconies that you might not even be budgeting for. You might not even be aware of, because they slipped this in very subtly into the statutory scheme, and they gave it if your documents say otherwise. And a lot of documents were written in a vague sort of way because there was a controlling statute, the 1364, that was on the books for years, and up until 2017 when they changed it. So it's a perfect example of where your documents could be bad news because you haven't budgeted. And it may be a situation where the entire membership is now having to fund maintenance, repair and replacement of a handful of balconies that everyone has assumed for years. No. The handful of owners, when they go to replace it, will work with them, but it's their responsibility. And now all of a sudden it's shifted to a general responsibility. And so it's something that your documents need to be looked at on a regular basis, because the legislature keeps changing the goalposts as to who does what. Use restrictions when it comes to documents. Your developer created documents, and even some of your existing documents, things change. Parking is by far the biggest headache that people have with associations. And so the question is, do your documents reflect the community's need for parking? Developers will often not think through some of the ramifications, how to do parking. Perfect example, they might say no parking on the driveway because they have very shallow driveways. And then as they're building the homes, they end up having 20-foot deep driveways. Well, shoot, you could park a car on a 20-foot deep driveway, but no, the documents say no. And so that's where looking at how your community actually operates versus what a developer initially envisioned it is something that you need to do. Otherwise, you end up for your community having bad documents, and that makes for bad news. Let's see. I'm an attorney. I can't not discuss some court cases that relate to document issues. There was a case called Starlight Ridge South Homeowner Association versus Hunter Bloor, and in that case, the CC&Rs said the association maintains front yards because it's an association maintenance area. Well, within the association maintenance area was a V ditch that provided drainage throughout the development. And there was some language in the CC&Rs that said, well, the V ditch is drainage. And this homeowner said, yeah, but it's in my association maintenance area. That's, I pay assessments. That's your guys' responsibility. And they got into a fight with the HOA, and they ended up going to court, and the trial judge said, yeah, you're right, homeowner. It's an association maintenance obligation. And on appeal, the Court of Appeals said, no, trial judge, you got it wrong. It's the homeowner's responsibility. And in that decision, the appellate court said, and I quote, the plain language of the CC&Rs could support either of the proffered interpretations. So great. Bad docs, vague, That was $100,000 minimum of legal expense and years of litigation, owners fighting with the association over an issue that could have been resolved had it been a, hey, wait, we got some confusion on this. Instead of spending money with lawyers, fighting over it, depositions, all this time, all this energy, all this emotional energy, let's just amend the document to create this bad news situation, make it go away. I mean, when your appellate court is saying, gosh, it could be either, that's a bad document. And that cost a lot of money. The other case is Dover Village Association v. Jennison. And in that case, the board of directors interpreted what they thought was the maintenance obligation for a drainage pipe, a sewer line that backed up, and it was confusing. And the trial court and the appellate court said, hey, time out. Board of directors, you're not the judge and jury on this. You don't get to decide what the legal contract, so to speak, is. Your job is to maintain things, but you don't get to decide whether it is a maintenance obligation or not. That is did the members vote for that or did the developer do that? But that case, again, lots of money spent over a misinterpretation of a provision. And so I really want to stress that when your documents have vague language, you're inviting fights over it, and those fights cost thousands of dollars and lots of time. And amendments can be, I'll discuss that a little bit later, amendments can take their time, but they're a heck of a lot less expensive, and they're not button heads with your neighbors over a particular issue. So things to think about regarding the documents is insurance. I had a situation recently where I'm representing a townhome style association where they have a shared roofing system, but everyone owns their own lot, and they share common walls. And the CC&Rs had language that talked about insurance as if the homes were single family detached homes that were separate. Didn't have the proper blanket insurance policy. And, someone spotted that, and we are now in the process of updating those documents. I should mention, as part of any governing document revision process, when you say bad documents, let's talk about insurance provisions. Have your insurance broker, today one of our sponsors, Carlin Insurance, if they're your insurance broker, have them look at any proposed language, both your existing language and anything that your attorney is proposing as a new revised or restated set of documents, to be sure that it has the proper language. As a member of a board of directors, California law gives you great protection because, you get paid the big bucks to be on the board, a big fat zero. You're a volunteer. The law says, hey, just make your decisions in good faith, in the best interest of the community as a whole. And then here's the key, and based on reasonable inquiry. So you're looking at this insurance provision. Is this do we have the right language for our insurance? Ask your insurance broker. You do that, good, bad, or indifferent. If it ends up not being quite right, you will have given it the college try that the business judgment rule requires. You will not have any liability, but more realistically, you're going to get the right information to get the right language in your documents. Something else to consider is sudden burst coverage. I discussed this recently, that coordinate with your insurance broker. Is that something that you can get if you have a condominium or a plan or attached plan development? That type of language, should you include that as a requirement so that future boards don't go, do I need this? Do I not need this? What should I do? A perfect opportunity to kind of correct or tighten up the documents so that future boards don't have to scratch their heads about, are they doing the right thing? The same is true with individual insurance in condominiums and attached plan developments. Should you require individual owners to have the HO6 policy, oftentimes called a tenant's insurance? Is that something that you should require, or you should put as an optional? that's something that you can decide as a group, as the citizens of your government, what you want your constitution, so to speak, to say. But that's a decision that you need to make looking at your documents. So regarding the amendment process, when a board is considering amending and updating the documents, the one thing they cannot do is they cannot advocate, we strongly encourage you to vote yes on this proposed amendment. The Wittenberg decision, Wittenberg versus Beach Walk Homeowner Association, held that a board cannot advocate for an amendment unless they're going to open it up for everyone else to provide their advocacy statements. And I'll just kind of whisper this. I think it's just a bad idea because it inherently, you're putting your finger on the scale as a board. If it's a good approach and a solid documentation, explaining it as to what's going on and why it's better should be sufficient. And something that I do encourage boards to do is do what a frequently asked question type of thing of, what will this amendment process do to our assessments? Because let's face it, people are like, okay, well, what's going on here? What are the key things you're trying to accomplish if you're in this governing document amendment or revision process? You want to spell it out. Is it going to cost members more money? What's going to happen if it's approved? And what's going to happen if it's not approved? And so that is completely permitted and in fact encouraged. Something else that I have found to be helpful is you need a minimum threshold of members to vote in favor. To vote to amend the governing documents. And we've used drawings and lotteries, and I think that the AMC's got one later on in this presentation, that everyone that votes is eligible for a drawing. I have no problem. You won't know how people vote because the legislature has now made voting an extremely confidential, private. How you vote, whether you vote is knowable. How you vote is absolutely confidential. So encouraging people, giving raffles for anyone who submits a ballot is a completely permitted process. And I should also mention, as part of my overall discussion of bad documents, something I didn't even mention, the legislature has fundamentally changed the elections process within the last couple of years and even prior to that. And because of that, you've all had to go out and spend a bunch of money to have statutory election rules put in place. But if you look at your election rules and you look at your bylaws and your CC&Rs, they're probably inconsistent because the legislature has radically changed the elections process. And back to my private government reference, where you've got this powerful government that says you will pay X dollars per month, and if you're late, we can take your home a year from now. And if we sue you, we've got all this legal leverage on our side, and we've got all the homeowners paying the legal bill of us versus you. It's all these factors come into play as to why you want the documents to be clear and members to understand, and the elections process to be fair. So, I mean, it's funny. I think oftentimes board members, nobody wants to run for a board, and yet they'll read about the local government doing something that ticks them off, and they don't appreciate the fact that the association board members, as a government, have a pretty strong say in people's lives, and getting people's input on what's important and how your money should be spent is something that is important. And so let's see, regarding the process. So, okay, I've given you kind of this overview of it. You're like, okay, that's all great, but what does all this cost? And Dwayne, I think it's safe to say of all the attorneys that specialize in community association legal issues. The range typically, and this is a big asterisk because there's always exceptions, but typically runs somewhere between $5,000 and $10,000 to go through the entire process to update your CC&Rs and your bylaws. So, and my battery's getting weak here. So, but that's the general expense involved is somewhere in that range for it. And so that's kind of my general, flyby discussion of the document revision process, is understanding that you're all part of this organization, this little small government, and you've all got a constitution with your governing documents. And the problem is the legislature keeps tinkering with it. The Department of Real Estate mandates provisions that are not applicable. And you're, as board members, you're trying to make decisions that you think are going to be in the best interest of the community as a whole, offering the highest value, the most desirable aspect, why your property is valuable and it's a great place to own and live. And you've got all these different factors, notwithstanding your governing documents. Here's the law. Here's the law unless your documents say otherwise. Here's the regs, the Department of Real Estate that don't apply. So all these things should encourage boards to look at your documents and decide, are we, from a governance standpoint, are we giving people a document that allows them to know what the rules are so that we don't slap their hand for not following it? When, as I like to say, Dean Warmer from Animal House, it was double secret probation, if you'll recall. And it always frustrates me when there's a gotcha. When there's a gotcha with, oh, I know what 4.02 of your CC&R said, but that doesn't apply because of this or that. And then when owners are frustrated with the board and they point at the documents and say, but it says this, and you wave your hand, well, yeah, but that was notwithstanding what your governing documents say, here's the law that we have to follow. Well, why didn't you tell people as opposed to having them guess? So that's, Dwayne, that's kind of my flyby with it. So you have any questions you want to, or anything you want me to address specifically?
No, I think that you've covered it pretty good. We've got some pretty good questions in our Q&A. So at this point, we're going to go to the Q&A section of our webinar. And our first question is from Cherry Sullivan. And Cherry, I'm going to open up your mic. I'm going to mention your question, but if you want to expand on it, we're going to see if we can allow you to talk as well. Let's see if we can unmute you. Asked to unmute. Okay. Your question is, can you discuss use of, for Cherry, are you there?
Yes, I am here.
Cherry's question is, can you discuss use of, is it resolutions?
Yeah, resolutions.
Bruce?
Yeah.
Yeah, to try to update governing documents.
Oh, got it. Yes. If it's a CC&R provision, it can only be altered or amended by an amendment to the CC&Rs approved by the membership. If it's a rule, it can be adopted by the board, and the board of directors can, on 28 days notice, propose a change to that rule. And following the adoption of the proposed rule, that resolution, i.e. change in rule, can take place. And the courts have held under, let's see, was it that versus, I'm trying to, which decision here? The courts have held that duly adopted rules get the same deference as your CC&Rs. And that was both the Terrafage decision and let's see, was it that versus Alder Main? I think it was that versus Alder Maintenance Corporation. So your resolution, if it's a rule, can be done by the board. If it's a CC&R provision, it needs member approval to change.
Thanks.
You bet. So what else?
All
you got?
right. Let's see here. We have another, let me just, okay. Now we have another question, and this is, let's see. It says, oh my God, this is overwhelming. And it is.
Yeah, true.
But they want to know, it says, we are going to have someone else rewrite everything because it's been amended for over 20 years. Let's see. And it says, this is from Lynn. And then how often should these need to be reviewed, Lynn? Question for Lynn.
Great question. Here's my demarcation line is if you look at your documents and they have a civil code section 1350, 1360, 1370, all of those are statutory references that no longer exist because January 1, 2014, they renumbered the entire statutory scheme to Civil Code Section 4000. So as a threshold, back to this, holy moly, it's a tax collecting government that tells you what you can and can't do with your property. And I'm looking at it and I can't even find the code sections because they're outdated. They're now 8 years old, or 7 years old, I guess. And so I would say if your documents predate 2014 and have the old language, strongly worth considering updating because of the fundamental changes in the law that the legislature has just piled on. If they're documents that were created by a developer, they have the declarant language, then it becomes a question of how much of this is, I'm not saying, oh, they have to be done. There's a side of me that says, how much of it has language that is just inconsistent with the vision of the board and the community as a whole as to what needs to be there. I will tell you that the threshold for bylaws for quorum is frustrating, and that's certainly a perfect example of one that you might want to consider. But if you're asking me for a kind of a hard date, I would say if your documents are pre-2014, you probably should update them. There's been fundamental change in the law, and the dang statutes themselves have been renumbered. That justifies it. Beyond that, I don't know, every 7 years or so, it's one of those things that nobody appreciates it until there's a problem. And so you want to do it only on a regular basis, but doggone it, don't have it done every 3-4 years. That to me is not a good use of your money or the attorney's time, frankly. Every 6, 7, 8 years would probably be my guess. Beyond that. So, okay, Dwayne, what else do you got for me?
All right. Let's see. We have a question from Deborah Sullivan. And I'm going to unmute you, Deborah, so you can ask your question. Here you go. Are you there, Deborah? Let's see.
Can you hear?
Yes.
Got you.
There she
Okay,
is.
we got you. Are you there?
There you go.
Again. Okay,
Okay.
I'm unmuted. Can you guys hear me?
Yes.
Yep.
I want to say thanks, first of all, Dwayne, and to the panelists, everybody, for allowing me to ask my question. I want to ask, when a person changes the rules, we have rule change, governing documents that are considered rule change, and you make a rule change in the rules for the parking, saying that people can be towed without any notice. But the CC&Rs says something else, and they haven't been amended, nor have they been updated. And you make a rule change, or the attorney writes them for us, and we present this and we put all this stuff in place. My question is this: If a homeowner is told, and they try to sue us and say, well, the CC&Rs says this. The CC&Rs is not lined up with your rules. Are we liable? Can we be sued? Can we be held accountable? Because the CC&Rs that govern us, the bylaws, the CC&Rs, are not written and standing in the same as our as our CC&R, the rules, the community rules. I think that's important, and I'd like to ask, very important. Can we be liable for that?
So a couple things jumping out at me. You can be sued for anything, number one, but
Okay.
winning is a separate story. But here's kind of the nuance I want to talk about. The Davis-Stirling, the civil code that governs your association, has a hierarchy, and it says if there is a conflict between your CC&Rs and your rules, your CC&Rs control. It's kind of like going to the U.S. Supreme Court and them ruling, no, this law is unconstitutional. It violates the Constitution. It would be, this rule violates the CC&Rs. Now, the important nuance here is oftentimes CC&Rs are written with lots of little wiggle room language that can allow that rule. So I don't want to say, oh, I haven't seen the document, so I don't want to say, oh no, that rule can't. That rule is a violation of your documents. It may or may not be, and that's that. I don't know. I haven't seen it, but that's something. I'm glad your question's a great one, because the law allows boards to kind of fill in the details of how things are done.
Exactly.
So long as they don't violate the underlying structure. And certainly on towing, one of the issues that jumps out at me is fire lane. Fire lane.
There you go.
If it's a fire lane, I don't care if it says, if your documents say you cannot tow. If it's a fire lane, the fire department says you need to mark this and sign this. You absolutely, you do not want an ambulance or a fire truck to be not able to get to a home because of an illegal parking. Oh yeah, we were told that was supposed to be a towaway zone, but our document said that we can't do that. Well, no. That's where the fire department's saying, I don't care what your documents say, you will not park in a fire in a fire zone. So that's,
we have a good one last little thing, if I may.
You bet.
We can trust the attorney. If we have the attorney that looks at the CC&Rs as it is written only for the parking, and we ask him to evaluate our community rules, the manual, he should be able to tell us or advise us whether or not we should rewrite those CC&Rs to amend them, right? He should give us that.
He or she.
He's supposed to protect us, right? He or she's supposed to protect us.
Well, yes. Now, here's the crazy part. The court cases that deal with this, and this goes to the Dover Village v. Jennison decision I talked about earlier, that the HOA attorney and the HOA board thought that the document said X, and the judge was like, no, it says Y. And that Starlight decision that talked about, gosh, there's two different ways of looking at it. A trial judge thought it was this, and the appellate court thought it was that. So what I'm hearing is, if there's ambiguity, that's the opportunity to get rid of the ambiguity, to be clear.
I hear you.
As part of your document process. But as a general comment, reliance upon advice of counsel is a key part of a board of directors. Not only their duty, but their right. Their duties are to act in good faith. Don't take money under the table. In the best interest of the community as a whole, and based on reasonable inquiry. And part of that reasonable inquiry is, hey, I got a legal question. I'll check with a lawyer. I got an accounting question. I'm going to check with an accountant. I have a management question. Management, AMC, what do you recommend? What's best practices in this situation? Those are all examples of, and you know what? Any one of those people can be wrong. The lawyer can be wrong, the accountant be wrong, but the board will have done their job, because they get paid the
fiducial duty. We did
Yep,
our
exactly.
fiducial duty. That's the word.
You bet.
Okay. Thank you, Bruce. Thank you, Dwayne. And thank you for all of those that gave me the time. I appreciate you.
Okay,
Dwayne, Allison has a question, and
I'm
then
going to unmute
Lynn
her now.
Corey.
I'm
Pardon?
going to unmute Allison now. Allison,
Allison,
are you? Whoops, hold on. I'm trying to unmute her now. Hold on.
yeah.
Howdy,
Someone?
howdy.
There she
Allison, are
is.
you there?
I know I'm in here as like Cora's double. It's not a very lengthy question here, but
Welcome.
our documents, thank you, are definitely pretty outdated. And I was just curious, as you know, from your experience of if it's a lengthy and also expensive process to get documents approved, both with your members and as far as getting them approved with the county, and what's the longest time frame you've seen?
Got it. The county, the cities and counties only have jurisdiction over the provisions in your documents that they mandated as part of the original development. And your attorneys typically won't touch those because they have a no amend clause, as an example. And so you're not needing governmental approval. You're needing the board to decide what they want and the members to vote on it. And that process can, sometimes, one of the dilemmas is, how many cooks do you want in the kitchen? Do you want to have a committee? Do you want to have a committee that comes up with it and makes recommendations? Or do you want just the board to come in? Portable basketball hoops. Oh boy, do we want to have special language or not? Some of those are issues that you can get wrapped around the axle of you throw the baby out with the bathwater pretty darn easily.
Oh, look at that little otter. That's cute.
I have I don't know, my son's or my wife's iPad, so my battery is fading, Dwayne. Just FYI.
Don't leave us yet, Bruce.
So,
All right.
Yeah,
What is it?
the reason I ask is our community is a little bit special, and half of our more than half of it was built after the fact, and it's a completely separate association. So just in speaking with the other association members, I know there's like a lot that goes on between us that's very unclear, that basically like they're not getting documents delivered to them, and they're under the understanding that it's because they weren't actually submitted to like the county, so they don't believe that they have to be provided to all of the members. So basically there's things that are getting changed that aren't being provided to members. So I didn't know if there was some kind of fine line with if it all ends up going to the county or not. So
got it. You know what, you just
I know.
mentioned something though that I want to slip in. I have done corporate mergers of associations where you've got two small associations. I've done corporate mergers where we merge them and create one. And the savings on them is amazing because each HOA has their own directors and officers liability insurance and their own liability insurance that have minimum costs. And when you combine them, I did one in Oakland a few years ago, and the entire process paid for itself in the first year. Their assessments went down $50 a door a month because of the efficiencies of having doubling the size of the HOA. And I just did one recently in Sacramento that combined two associations, and we saw in our FAQs, we got to say, what does this do if it's approved? Your assessments will go down. So something to consider for small associations. If you're part of one that's nearby, there are ways of doing it that preserve the financials, but make it cheaper for everybody.
Thank you.
Okay. All right. I think we have another question. This is from Lynn. Lynn asks, if the CC&Rs overrule the rules, why is the board allowed to make rules?
Where your documents typically are written, that additional rules to kind of fill in operational aspects can be done by rule. They're not meant to be contradicting. For example, think of this, if your HOA has a swimming pool What are the hours of operation of the pool? That's going to be a rule. It's not typically going to be in your CC&Rs. So it's some of that's just the operational side of it, of when to slip it in.
But it doesn't overrule a CC&R.
Correct.
It's supposed to be done to complement it, not overrule it.
Correct.
Okay. Okay. Thank you.
Okay.
Let's see, are there any more questions? Let's see, are there any more questions? Okay, if there are any more questions, please include them now. Otherwise, I believe that Barbara Lemaster has a question. Barbara, do you have a question?
I did have one last question. So previously, neighbor-to-neighbor disputes were within a homeowners association, typically not the board's responsibility, right? So then fair housing came along a few years ago and now has essence said that the board and management should help mediate or eliminate these neighbor-to-neighbors, including potential racism, discrimination, so forth. So is there any chance, if they're going through a revision, is there something they should or shouldn't add to their governing documents in order to protect them or give them guidelines as to how to move forward with that?
That's a great question. You know, you're right. Neighbor-to-neighbor disputes are something associations try to get around, and to the extent they're kind of being pushed into dealing with that, a more refined dispute resolution process for neighbor-to-neighbor disputes could be helpful. One that, as an example, that that instead of running off to court, that the neighbors agree to submit it to the board for determination or to a third party, but to avoid having them escalate. So yeah, that is definitely something worth considering. If your community's had those problems, the ones that have not had them, there's kind of an element of, do you want to open that up to encourage it or not? But definitely if that's been an issue, I would encourage it. So.
Thank you.
We have one last question from Carol. Let's see.
Quorum.
Minimum
It's on
amount of,
quorum.
sorry?
She's asking about quorum. Is there a minimum amount of owners who must vote on new CC&Rs?
Yes. Typically the minimum amount is I want to say 51% of the members must approve the amendment. It's not so much a quorum for how many people vote, but you need an affirmative vote of at least 51%. So if you have 100 members of your association, you need 51 yes votes, not 51 people voting, but 51 people voting yes. Which is why we don't want to have to go through this process that often. You need people to actually vote for governing document amendments.
Okay. Well, with that said, I guess that wraps up our Q&A. Bruce, thank you very much for taking the time to answer all those questions. I need you to hang around because if you still have power left,
I have 3%.
I need you to help us with our raffle. All right.
Okay.
All right. So now we're going to do our famous AMC raffle. I'd like to let you know that this raffle is sponsored by Farmers Insurance, the Carlin Insurance Agency, also Arborwell, the Save a Tree Company, and Kelly Moore Paints. Okay. So how we do the raffle basically is this way, Bruce. I ask you to select a number from 1 to 10. And we do this
1
3
to
times.
15, 1 to 13, I'm sorry.
1 to 13.
Yep.
Well, that would mean that the AMC people could enter the raffle.
No, not including AMC.
Got it.
Barbara is my Zoom expert, so I defer to her. So Bruce, pick a number from 1 to 13, please.
So I would normally just say pi just to really mess with you, but that's not exactly. So I'll do 3 because I can't do 3.14. So
3. Dorothy
3.
Mendoza.
Who is that?
Dorothy Mendoza from Villa Terraza.
All right. All right. And next up, we have three prizes in our raffle today from our sponsors. So Bruce, would you please pick another number from 1 through 13, please?
I'll do 7, 13, and 9. And I only say that because I'm at 2% power, so I might go out.
All right.
Okay, so 7 is Dawn Seibert. I hope I didn't ruin your name. Seibert?
He's a double winner. Great. Okay.
He's number 7. Number 9 is Lynn Corey, Rockland Park Place.
All right.
And then Deborah Sullivan, Villa Terraza.
Okay. Fantastic. That concludes the raffle. And that concludes our webinar. On behalf of AMC, our staff, our president, Mr. Brad Higgins, and everyone that joined us, we thank you. And our next event is going to be, our next workshop will be July the 28th. So stay tuned and join us then. Again, thank you. And hopefully you got some good information from this. Thank you, Bruce. Enjoy your
Thank
vacation.
you, Bruce.
Thank you.
Thank you, guys, everybody.
Thanks, everybody.
Great workshop. Enjoyed it.
Thank you. Bye-bye.
Bye-bye.
Bye.